Hello, my name is Josh Blackman. I am the president of the Harlan Institute, and it's my honor to welcome you to the 2021 Virtual Supreme Court competition. This is the semifinal round. For our first round, this is match number one. We have Claire Rudinsky and Heather Tom from Lake Oswego High School. And we have Brian Kang and Angela Nguyen from Creekview High School in Texas. And today we're arguing the New York State pistol and rifle case, a Second Amendment case. Okay, petitioners, whenever you're ready, you may begin. And respondents, please turn off your cameras and we'll get started.
Thank you, and may it please the court. Today we ask the court to rule that the state's denial of petitioners' applications for concealed carry licenses for self-defense violated the Second Amendment. The individual petitioners of this case, Braden Kosh and Robert Nash, were both denied concealed carry licenses after submitting the necessary documentation and monetary deposit in September of 2014. Nash was motivated by a recent string of robberies in his neighborhood, and with a background in gun training, he believed he was a strong candidate to receive a general concealed carry license, as he had both a recent and a dependable history. Kosh cited his concerns for self-defense and his extensive firearm usage and training in his application for a concealed carry license. Neither had any criminal history, and yet they were denied for the same reason. They did not provide a special need or unique threat that met the standard for proper cause. Both petitioners had previously gained a license to carry arms outside of the house for hunting and target shooting. However, they applied for this license with a desire to carry outside the home in self-defense as well. Sensitive zones such as schools and government buildings are not included in such a license. Having proven not only that they are law-abiding citizens, trustworthy of previous carrying licenses, but also that they have the necessary training and expertise to skillfully and carefully wield these firearms, these model American citizens were still denied their constitutional right. The New York Rifle and Pistol Association joined the lawsuit in an effort to defend all New Yorkers who have been denied the concealed carry permits due to a perceived lack of a proper cause, as mandated by New York Penal Law 400.
The court in DC v. Heller clearly shows that historical text, tradition, and history must be examined to determine the validity of this law.
Okay, let me, counsel, if I can just stop you right there. So you cite the Heller case, and you said it clearly supports your case. Did Heller resolve the issue of what the Second Amendment means outside the home?
Well, it doesn't specifically address outside of the home. It does say that the verbiage of the Second Amendment, the words to keep and to bear, they point to a situation where carrying is for the direct purpose of confrontation. And as we know, confrontation doesn't just happen inside of the home, but outside as well.
No, I get that. I know there's definitely language, but I think you said clearly. So does Heller really clearly point? Does it clearly, in other words, does Heller resolve this case, or is there still stuff that we have to decide anew for this decision?
I completely agree with you. I think there are still things that Heller did not address, and that is why we have the case.
Okay, all right, you can proceed, counsel.
Thank you. As stated in Heller, the Second Amendment is an individual right for the people, similarly established to the rights in the First Amendment and the Fourth Amendment, which both also use the language of the right.
Counsel, pardon me for interrupting, but how exactly did the court in Heller come to that conclusion, how the First Amendment informed the Second?
So the First Amendment and Fourth Amendment both also use the language of the right of the people, and this right is still an individual right. It's not a collective right that is required of people to be a part of a collective to use.
Sure, but how do you square that with use of the word militia?
The militia part is actually part of the prefatory clause. It's stating why perhaps it's necessary, but the Second Amendment could be rearranged and still have the same meaning, which doesn't require use or membership in a militia. When referring to a collective right, the framers use only the people, as seen with the preamble and the 10th Amendment. And even then, it is a reservation of powers, such as plenary power, rather than a collective right. Heller also alluded to a larger Second Amendment right, as they wrote, it guarantees the individual right to possess and carry weapons in case of confrontation. Neither in the founding era nor modern time do confrontations merely happen in the home, and therefore the Second Amendment should include a right to carry firearms for self-defense outside of the home. Indeed, there is often more of a need for self-defense outside of the home rather than inside, both in historical context and modern.
So, Counselor, let's say we agree with you for a minute that the Second Amendment extends outside the home. What does that tell us then about whether New York's law in particular is valid?
Well, New York's law.
And we could maybe your partner answer. Let's try to alternate questions. It helps to mix things up a bit.
Yes, of course. So even if it does extend outside the home, this law still is completely unconstitutional because the main problem with the law is the subjective manner in which the licenses are given out, because they need a specific magistrate, depending on the county in New York, that has to approve the license, thus leaving it up to the whims and biases of that individual.
Well, let me just pause you. I mean, I understand that, usually if I live in one county and you live in a different county, our local officials make our decisions. It's where we choose to live. I guess we can't pick our government, but it's where we live. Where's the bias? Is there any evidence that, it's whims and bias? Is there any evidence that there's bias, that they're discriminatory on some protected basis?
Well, the system is set up essentially so that an individual judge or magistrate has to make the decision. And while we don't have any specific interest examples from this exact law, the same structure of law has been used throughout history. For example, similar laws were in Florida in the late 1800s, and these were later proven to be intended to discriminate against Black individuals so that they couldn't own a gun. And these had like the same structure of an individual magistrate needing to approve of the license.
Well, I mean, that's a fascinating argument, Counselor, about history. And I'm with you. There's a lot of history that gun control laws were used to disarm the freedmen after the Civil War. But I mean, we're talking about New York in 2022, right? We're not in Alabama in the 1870s, right? So help us bridge. Why is that history relevant to interpret the Second Amendment today? And you could go back and forth between your teammates.
It's still relevant because even if this gun control law may not have be used to discriminate at this given moment, it still has the structure to be able to do so. If you see a change in political beliefs in the government, there are still the perfect then legal setup for them to continue doing this.
And just one specific example is in the county of Westchester v. Kalowski. A transgender woman applied for a gun license and she was denied this gun license because she didn't face a specific and unique threat, despite the fact that transgender individuals on the large are facing larger violence in the United States.
I have a question. How specific does the threat need to be? Does someone need to literally come out and say, "I will kill this person"? I'm curious.
It has been established through the New York courts that it does have to be a fairly legitimate threat. For example, perhaps a threatening note or a domestic abuse situation or something like that. And a more general threat that affects the whole community is not accepted.
Early 19th century Americans often faced dangerous situations such as animals or hostile individuals outside of their home and therefore carried a loaded firearm with them. Nowadays, there is still danger outside of the home, even with the vast implementation of the police. Around 50% of murders and 40% of assault charges occur outside of the home.
Well, let me just pause you for a second, Counselor. When we speak about outside the home, there are lots of places outside the home. I mean, in your argument, would you allow people to conceal carry on the subway? It's a very crowded area under the ground. People kind of packed in tight like sardines. Would you allow concealed carry on the subway?
I think that in that situation, it would be in the state's best interest to bar people from carrying guns on the subway. However, that's still on a state-by-state basis.
But why couldn't you carry in the subway? There's lots of crime in the subway. I'm sure we'll find statistics that people get mugged and robbed and raped on the subway. Why wouldn't that be a good place where you would want to have law-abiding citizens carrying arms for self-defense?
I think it depends on the specific subway, Your Honor. For example, in New York, the entire city of New York is.
So on the 7 train you can carry, but not on the end of the R. I mean, I'm trying to be just. I know you guys are in Oregon, but is it really going to be which subway line you're on?
No, Your Honor. I think that'd be a bit too much of a burden for the state government. But I think that the state government should have the ability to kind of take that on themselves.
What about on a college campus?
I do think that there can be protected zones such as schools or government buildings, and this is still.
But what about, let's say, Columbia University, which is somewhat close to Harlan, which has had a recent spate of shootings? Could you carry on the Columbia campus at Morningside Heights, New York?
While it isn't exactly, the burden isn't fully on the petitioners to provide an exact example of, and the rulings of where it should or shouldn't be allowed.
Good answer. You have 30 seconds left. You want to just wrap up and give a little bit of a summation, please. Go ahead.
So when looking at the text, tradition, and history of America, New York penal law fails to meet the standard of strict scrutiny or even intermediate scrutiny and must be declared unconstitutional. The Second Amendment establishes an individual right to keep and bear arms both in and out of the home, as shown with historical and legal precedent. The language of the right of the people is analogous with other individual rights given in the Constitution, and this was openly affirmed in DC v. Heller.
Okay, thank you, Counselor. And when the clock strikes red, that's, at the U.S. Supreme Court for real. When the clock strikes red, that means you. Now it's, oh my goodness, it's flashing red. That's awful. That means you got to wrap up. All right, but thank you, Counselor. All right, if the petitioners can please turn off their cameras, and if the respondents can come on screen, please, and we will begin your time whenever you're ready. Okay, whenever you're ready, Counselor.
May it please the court, my name is Brian Kang. Along with my co-counsel, Angela Nguyen, we represent the respondents Brew in today's case. The issue at bar is whether the state's denial of the petitioner's application for concealed carry licenses for self-defense violated the Second Amendment.
While the petitioner has covered most of the facts, we would like to point out that the key point in today's case is not the question of the applicant's legitimacy in their alleged cause. In this case, the petitioner contends to possess a gun without alleging any cause whatsoever. They're not expanding which causes are and are not just. They're only asking this court in New York to not require cause at all, which is not aligned with past precedent. In the case before the court today, we will argue that the state's denial of the petitioner's application for concealed carry license for self-defense did not violate the Second Amendment. In response to opposing counsel's contentions, we would like to argue 3 points. 1, petitioner relies on Heller and Miller for precedent. However, these cases can only apply to the extent of the interior of one's home. Secondly, the proposed remedy is contradictory to the petitioner's contended interest of a safer society. And 3, after analyzing New York's gun regulation, it survives both prongs under intermediate scrutiny. The court should find in favor of the respondent for 2 additional reasons. 1, in all relevant points in time, states had similar prohibitions on the Second Amendment's protections in effect. And 2, other amendments contain similar limitations to New York's licensing restrictions. In our rebuttal, even though confrontation does not merely occur inside the home, there are other circumstances that must be considered when applying Second Amendment protections. We agree that confrontation is one of many factors that contribute to the right to keep and bear arms.
What are the other factors, Counselor?
Your Honor, we must factor in such as what other property and other people that this right is extending to protect. For example, in supporting this claim, petitioners cite Heller, which recognizes the right to apply inside the home, not the application of the right outside.
Why does it only apply inside?
The right is recognized inside the home due to the clear and distinct purposes of self-defense, such as robberies or even attacks within the home. And the court must also look to the definition of self-defense and its application within the case presented today. As defined by
Mr. Kang, is it your contention and your co-counsel's contention that the framers had only in mind robberies and burglaries when they wrote the Second Amendment? Is that what you're telling us today?
Well, Your Honor, no, that's not the case here. What we're trying to contend here with the intention of Heller is that in a setting of a home, a person clearly knows what they're protecting, their property, the people they're with. However, when applying this right outside the home, they do not have that clear intention. We do not have the clear intent of who they're protecting, what they're protecting, and therefore we should apply Heller in that instance.
Your Honor, to add on to what my co-counsel said, whenever applying self-defense outside the home, it is unclear what they are protecting themselves against. However, again, to reiterate what my co-counsel has said, within the home, there's more to protect than only self-defense. Furthermore, as a general rule, modern self-defense law continues to maintain the goal of protecting life, as it considers deadly force unreasonable to, quote, prevent a mere trespass or theft of personal property, regardless of whether the harm could not otherwise be prevented. The value that the American legal system places on the preservation of life applies not only to the defender, but also to the alleged attacker.
Your Honor,
if I can interrupt, let me ask you the same question that I asked your friends on the other side. Does Heller resolve this case? In other words, how much do we have to actually decide in light of Heller?
Well, Your Honor, we rely on Heller for the question of to what extent the right of the Second Amendment applies. Your Honor, while opposing counsel relies on precedents from Heller and Miller, stating that there cannot be a complete ban of the possession and usage of handguns, the least restrictive thing we can do here to extend the right of self-defense beyond the home is not to ban guns as a whole, but to provide
let's just stick with Heller for a minute, right? Heller said that the government can ban guns in sensitive places, right? That was in Heller, which suggests that there are some places that are not sensitive. Isn't that a pretty good recognition that this right extends beyond the home? If they can ban in sensitive places, that means that in non-sensitive places that you're allowed to have guns. How'd you read that passage from Heller, Counselor? Angela?
Your Honor, could you repeat your question one more time?
Sure. Right. Heller said that the government can ban carry in sensitive places, right? Schools, right? Maybe the subway, I don't know. That suggests that there are some places that are not sensitive that carry would be permissible. How do you read that passage from Heller?
Well, Your Honor, with the restrictions in sensitive places, such as in schools or in a subway, with that, the laws that are set have to be analyzed under a specific scrutiny, therefore meeting such governmental interests.
All good, but didn't Heller at least recognize implicitly that there was a right to carry outside the home? The fact that they said, if Heller just said the government can ban carry outside the home, period, then I think you'd be on strong ground. But they said you can ban carry in sensitive places. What about not so sensitive places?
Your Honor, I believe because they did not define the exact difference between sensitive and insensitive places, what we can do here is just not ban guns as a whole, but put restrictions. I believe that since there are gray areas in that part, what we can do is not ban guns as a whole, but just put restrictions on
I just want to make sure, counsel, are you conceding that there is a right to bear arms outside the home? Are you conceding that point?
No, Your Honor.
Well, I think you just said restriction, but not ban. So, I mean, right, if you can ban it, that means there's no right, but if you can only do restrictions, that means there's some right, but subject to restriction. So is there actually this right outside the home? I want to just make sure I get your position.
Yes, Your Honor, there is a right to carry arms outside the home, as the New York's restrictions don't put a blanket prohibition on the carry of guns. However, it puts the extent whenever it is only for the mere purpose of self-defense.
Okay, so you think the Second Amendment protects a right to carry the gun for self-defense outside the home? I just want to see what your argument is. I want to make sure I understand it.
Yes, Your Honor. We believe that for the purposes of self-defense, to bear arms only applies to the interior of the home. And if this right were to be brought outside the home, there must be a proper cause shown as listed in New York's regulation law.
I'm not sure if I'm following your. So let me ask the question. Does the Second Amendment protect the right outside the home? Yes or no?
Yes, Your Honor.
It does. Okay. And so what is that right outside the home?
Well, Your Honor, with the right outside the home, it protects an individual to bear arms if there's more than just self-defense, if there is a proper cause to keep and bear arms outside of the home. And as previously stated, there is more than just to protect for self-defense within the home, such as property or other family members, things like that. However, that distinction is unclear once the citizen has stepped outside of the home of who or what they're protecting besides themselves.
Okay, so how do you draw that rule from history? In other words, how do you know this proper cause standard? How do you know that's the right standard? Where do you get that from?
Your Honor, according to the Second Amendment of the Constitution, it talks about militia being necessary to the security of a free state. And we come to this conclusion of probable cause looking at other amendments as well. There were several restrictions placed on the First Amendment and the Fourth Amendment and the Fifth Amendment, allowing us to put restrictions on Second Amendment as well. Your Honor, for example, for pertaining to the First Amendment, this court in Brandenburg held that states are able to restrict speech that is directed to inciting or producing imminent lawless action. That was a restriction placed on an amendment, and following what our history has shown and with following precedents on other amendments such as the First, Fourth, and Fifth Amendment, we can use that probable cause analysis and place those restrictions in our Second Amendment analysis today.
Well, I mean, let me ask, I think Justice Krill asked this question a minute ago. How do we know that we can simply use precedents governing the First Amendment for the Second Amendment? I mean, you made an argument, Brandon, which I think was a fair argument, but how do you know you can just extend the precedent from one amendment to another? Where do we get that rule from?
Well, Your Honor, it's not only just one amendment to another in the sense of just because we can place one regulation on one, we can place on the other. It has to be proportionate to the amendment and the restrictions, and analyzing it under the proper scrutiny analysis. We look to Robertson v. Baldwin, where it uses the First, Second, Fourth, and other amendments as examples. And directly quoted, it says, "The right of the people to keep and bear arms is not infringed by laws prohibiting the carry of concealed weapons." With the Second Amendment, it was used as an example, as the law is perfectly well settled that the first 10 amendments to the Constitution, commonly known as the Bill of Rights, were not intended to lay down any novel principles of government, but to simply embody certain guarantees and immunities which had inherited from our English ancestors. And with this, we want to reiterate that these rights are not unlimited outside of the home, and to set such restrictions are to provide for a safer society that the petitioner contends.
Okay, thank you, counsel. You may proceed with the argument.
Oh, Your Honor, additionally, it is our contention that we have an interest in providing self-defense and a safer society. But according to various studies, the remedy actually results in more violence and an increased risk of a more dangerous society. By having fewer guns and stricter gun laws, it has been shown that there is less gun violence and a substantially reduced number of gun deaths. Miller Matthews supports this conclusion in his book, Reducing Gun Violence in America, that gun availability greatly increases the risk of violence and deaths in America because many acts of gun violence involve spontaneous altercations that result in death or serious injury when a gun is readily available. By opening the door—
Counsel, let me ask you a question. This might be a little bit of a difficult question, but I'll try. How should the court consider public safety implications when we're deciding these cases, right? I mean, are the courts really set up to make these decisions based on, statistics and these various figures you're giving us? Or are we just a court of law that decides what does the Second Amendment mean, and we're just going to, that's it, wrap up after that?
Well, Your Honor, to regulate all guns in the United States is very disproportionate. I would say the least we can do is restrict it. And well, Your Honor, could you repeat your question? I didn't get the second part.
Sure. We're a court of law. How should a court of law be prepared to make decisions based on statistics and figures and public safety directions? Are we even equipped to make those sorts of judgment calls? I mean, is that for us to even decide? Who decides these questions, if I may?
Well, Your Honor, in order to come to such conclusions pertaining to the law, how we apply and incorporate the law within our everyday lives for modern application, to come to these contentions, we have to look at what is happening in modern society, what governmental interests do we have in such events happening. And in this case, we look to such statistics contending that in order to have less violence and have a safer society, as the petitioner contends they are trying to protect, we have to have such stricter gun laws in order to only provide guns to those who truly need it and those who show the proper cause.
But do courts have the competency, the ability to even make these sorts of judgment calls?
Well, Your Honor, I believe that we don't rely on only the statistics, but additionally, the other amendments that have also had such restrictions placed on it, various cases proceeding that have ruled on the regulation and the state's legislature to regulate such gun control laws and laws of that sort. We agree that only to rely on simply statistics is not what the court of law is built upon. However, we look at the statistics in addition to preceding cases in order to come to a conclusion.
Your Honor,
Yes,
Your Honor.
Why does this pass intermediate scrutiny?
Your Honor, under intermediate scrutiny as the respondent, we must prove how New York's regulation, 1, furthers a governmental interest, and 2, is substantially related to accommodate for such interest. Regulation vital to the protection of public health and safety, including the regulation of violent crime, the requirements of national security, and respect for fundamental rights as an example of compelling governmental interest, as previously held by the government's decision in Jacobson, supports this claim. And keeping this in mind, New York's regulation would undoubtedly fulfill the first prong, as it demonstrates the furtherance of an interest in public. And respect to the second prong, we must also prove how the law is substantially related to said interest being the least restrictive means. Your Honor, we are not here to ban the guns, and by providing restrictions and by asking people to provide probable cause for their reasoning in carrying a license is a least restrictive means that we are proposing.
In addition to what my co-counsel has said, I would like to reiterate that we do analyze the gun regulation under intermediate scrutiny. However, it still does pass.
Sorry, Counselor, why are you picking intermediate scrutiny? I mean, where does that come from? Why are you making that decision?
Your Honor, in a Justice Scalia decision, it has stated that such gun regulations law pertaining to the Second Amendment are gun regulation control laws are presumptively constitutional. And
Sorry, what case was that? I didn't catch that, Your Honor, or counsel.
I have it in a I have it quoted from just Scalia in the fundamental right.
Yes.
Oh, Scalia.
Yes, yeah.
Okay.
Your Honor, moving back into my argument, we are not saying that it must only survive intermediate scrutiny. It can also survive strict scrutiny, as relying on the precedent set in Jacobson v. Massachusetts. It shows that there's a compelling governmental interest in public safety, and the least restrictive means is through this process, as we're not creating a blanket prohibition on the ban.
Your Honor, in conclusion, the court should find in favor of the respondent for the aforementioned reasons. To rule in favor of the petitioner would not only advance their interests in a safer society and would in fact have a contradicting effect without a restriction on being able to carry guns.
Okay, excellent. Oh, with 8 seconds, very good. Thank you, Counselor. Okay, petitioner now has 5 minutes of rebuttal time. If you can come back on camera, please. And you can begin whenever you're ready, Counselor.
Thank you, Your Honor. May it please the court. So we are first going to address their verbal arguments, and then with spare time, we will go back over their brief. So one of the first arguments that they made is that we are essentially saying that we don't require cause at all. And they essentially claim that we are then saying there should be no restrictions on gun regulations. However, this isn't true. This isn't what we're arguing. We are simply saying that this specific law is clearly unconstitutional. We are still in support of, say, objective background checks as opposed to subjective laws. For example, in their brief, they actually mentioned the National Instant Criminal Background Check Improvement Act. And this is essentially an objective background check that would still improve safety, and we fully support this. We also support other methods of gun control, such as shall issue permitting, which is constitutional, less restrictive, and still has been associated with the same rates of safety. They also say that they win under the fact that they survive all the prongs of intermediate scrutiny. However, they seem to acknowledge that we're using strict scrutiny in their brief. They say, quote, the limitations on the Fifth Amendment itself exemplifies how states have a compelling interest in preventing the rights guaranteed in the Constitution from becoming too powerful, end quote. So using this language, they are implying that they are using strict scrutiny to analyze this case, so we should be operating from that. They also say that there is a right to confrontation inside the home, and we believe that this does also apply outside of their home. In their brief, they also mentioned castle doctrine, which does allow the right to extend outside the home, and it allows people to carry and use their weapons in self-defense outside of the home. So they
but the castle doctrine only applies to very limited areas outside the home. Am I correct in that, Counselor?
Yes, you are correct. I was simply saying that they seem to then support the idea in general, though, of people being able to use self-defense outside the home, which then contradicts the idea of having a gun that lays essentially a blanket ban, which they say it wasn't. However, the petitioners we are representing had no legal problems. They were fully prepared citizens and they still weren't able to gun. So it does come off as a blanket ban.
Once again, addressing their interest in public safety, they argue with several statistics that increased gun licenses causes increased gun violence. However, the evidence on this is still being heavily researched, and gun licenses have actually.
Let me ask you the same question I asked your friend on the other side. Who gets to decide these statistical questions? I mean, maybe the answer is if there's a debate about Group A says the statistics go this way, Group B says statistics go that way, maybe we just defer to the elected branches. Why are we as unelected judges? We're sitting in our ivory towers, right? Marble palaces. Why are we deciding these cases?
Yes, Your Honor, I agree with you. I think that in the case where there's statistics on both sides, it should be left up to the legislation. But in
So don't you lose here?
No, in this case, we are deciding the constitutionality of this law, as it is bringing it is placing an undue burden on the people of New York to prove that they have a proper cause simply to obtain a gun license.
Additionally, building off of what my colleague said, we still wouldn't lose on the basis of statistics because there are actually a significant number of statistics that support our side. For example, we need to address the issue that most violence is actually caused by illegally obtained firearms. So none of this regulation would actually significantly help. For example, around 60% of homicides are caused by illegally obtained firearms. And
Where are you
But
getting that,
I'm sorry, Justice
no.
Kellogg, you go ahead.
Well, where are you getting that, counselor?
the
Your
Poynter
farm statistic.
Institute, from a research study by the Poynter Institute, sorry. And additionally, shall issue permitting, which is extremely less restrictive, has been associated with similar rates of safety. So in this case, we don't lose on the basis of statistics.
But shouldn't New York, and actually, you know what? You have about 40 seconds left. You can wrap up and give your conclusion. I don't want to rush you this time.
So overall, our opponents, due to the fact that the New York Penal Law 400 blatantly violates the 2nd and 14th Amendments, while also failing under historical text, tradition, and history, strict scrutiny, and intermediate scrutiny, we ask you to vote in favor of the petitioners today in order to uphold the rights of both the people and our legal system.
Okay, excellent. Thank you so much. Wow, you guys are wonderful. I have to tell you, and everyone, just please come back on camera if you can. This was really hard. The way we were asking you questions is the sort of way that you get questions in a law school moot court competition. And you guys are like, what, 16, 17 years old? It's really, really remarkable. What I really liked that you all did was that you sort of reacted to what your other person was saying. You weren't just sitting there like a potted plant going through, prepared remarks. You responded to what your other colleagues said. Also, when we asked you a question, you stopped, right? You didn't talk over us, which is actually really hard. I know you want, because you guys are so smart and you have all these ideas. We have to kind of just sit and listen to us as we hit you with questions. And you didn't break your flow, right? When we started asking about X, Y, and Z, and said, okay, thank you. And you went back to your script. That's very hard. So this was a really hard topic. We get you some really tough questions. I thought you did great. Reed or Ashley, anything else, any kind of feedback you want to give to the students?
I just can't believe y'all are 16 or 17. I want to know what law school you go to, because this was very good. I did a lot of moot court, and this is better than what I've seen third-year law students do. So it's very impressive. The one thing I will say, though, across the board, slow down a little bit. Give us that little beat of silence so we can jump in with the question. You want the questions, so you're just having a conversation with the judges. But other than that, guys, great job.
No, I agree. I was very impressed with all of y'all. I think you took every question that was asked and thoroughly tried to answer it to the best of your ability. And yeah, just like what Reed said, I cannot believe y'all are in high school. And I think everybody did a really great job.
Thank you so much. All right. Do you have any questions for us or things that you want to ask us? We're open for any feedback or any thoughts you have at law school or whatever else.
Do you have any like general advice for law school in general or anything like that?
Well, I mean, look, there are many ways of going about it, right? Some people major in undergraduate, right? In political science or pre-law or these various other things. I didn't. Reed, did you?
I poli-sci.
And Ashley, I don't know. Would you study in college?
I was a business major.
Okay, so and I was computer science, so we're all across the board. There's not just one path to law school. What does help you is knowing how to write. We're putting a lot of focus here on the oral, right? But most what lawyers do is actually writing. The briefs are more important. Most of the hard work comes before you get to this point. So whatever you choose to do in college, learn how to write. It's a skill that will never leave you. If you have mock trial or moot court in your college, try it. See if you like it. Maybe you don't. Maybe you want to do something else. But I can tell the four of you are pretty sharp, and I think you're well on your way to winning moot court championships. And like Reed and Ashley are two students here at South Texas. They're at the top of their class, and when they're giving you good feedback, they're not just puffing you. They actually mean it. All right. Garrett, you have any questions for us? Mr. Camping, I always like to give the teacher some credit. Either Garrett?
Yeah, I'm here. No questions for me. Glad we're doing it again.
It's good to have you back. All right.
Yeah, no, it really is.
Well, that's all we have for you guys. We'll have the scores probably on Monday or so. But thank you so much. And you have my contact information. Email me anytime if you have any questions. And thank you.
Thank you.
Thank you.
All right. So if the students could just sign off, I'll just talk to the judges for a bit. Okay, and let me stop the recording.